We are very happy to have you here, and it's very great to see Director Natalia Shuklina, all Ukrainian experts, judges, and legal experts interested in the discussing the issue of admissibility and jurisdiction of the International Criminal Court. Well, this is the next step of discussion, or the next discussion about the same general topic. We all sustain the right of Ukraine to bring perpetrators of those horrible crimes to justice. But how to bring justice for those crimes? How to effectively prosecute war crimes, crimes against humanity, crime of aggression? This is obviously a broad question. One of those questions that we see in the front of us is which would be the court before which we should bring the cases. We obviously can discuss about the national Ukrainian system as the first answer for the question whether we should go for justice. But we already know that not all the cases can be brought before courts in Ukraine. And maybe we should ask another options for those crimes committed on a huge scale during this Russian aggression. So we also can discuss hybrid systems, as we know from the history of international criminal law. We can also include this discussion about the ad hoc tribunals, as we had examples from Rwanda, ICTR, or Yugoslavia, ICTY, and the idea of a special court for Ukraine discussed lately. And probably this is a topic for one of our next conferences, which I already invite you, should take place in May. This is also a question of universal jurisdiction and possibility of prosecuting crimes by different countries. We know already, and we take part in the discussion of checking possibility of opening cases in different countries. Also quite far countries like Australia or Canada. The countries that are discussing this, and they are checking the conditions under which this universal jurisdiction can be used for the cases. But when we have this discussion, we have to remember that finally we have the Rome Statute of the International Criminal Court. And finally, we have a court dedicated to situations like these. When war crimes are committed, when crimes against humanity are committed, when aggression took place. This is the reason why the ICC, International Criminal Court, was originally organized. That's why we have the ICC in The Hague. So the discussion that we have today is answering the question whether can we and under which conditions we can use the International Criminal Court for those two purposes that I mentioned in the beginning. The first one, to bring justice, and the second, maybe effectively prosecute and then bring justice. Execution of jurisdiction of the ICC and specifically complementarity of jurisdiction of the ICC. So admissibility of the case, of bringing cases before ICC, is the direct topic of this discussion. On the broad perspective that we should see, we have two excellent keynote speeches today that will deliver presentations. First one, Professor Karolina Wierczyńska, and us later on, Professor Hanna Kuczyńska. Professor Wierczyńska will present us the idea of complementarity. We'll discuss criteria of accessing actions of states and conditions under which the ICC can open investigation, can open a case, and can use its powers to prosecute and then bring before justice. So we will have the analysis of the criteria of complementarity and answering question whether the state and under which conditions can be understood as acting effectively to prosecute a case. And probably also other criteria as, for example, gravity of a case in the perspective of admissibility before the ICC. I'm with the great pleasure giving floor to Professor Wierczyńska, reminding that for the speech we have 20 minutes for the purpose to have a discussion after those presentations. Professor Wierczyńska, please, the floor is yours.
Thank you very much, Professor Wiliński. Thanks to the organizers for bringing me here, and thanks for Madame Natalia Szuklina for her introduction. At the same time, I would like to thank you all for coming here. I know you are struggling with your time, and it's very complex for you to be here with us. I will speak about the admissibility of exercising jurisdiction by the International Criminal Court, and I will focus briefly on those issues of admissibility. Okay, I moved the slide. And when we take the preamble of the Statute of the ICC, there are two fundamental provisions referring to the issue of complementarity. First one is that it is a duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. It actually means that every state has this jurisdiction, not only the state when the crimes were committed or where the crimes occurred, but all states. So it means in the context of Ukraine, that also, not only Ukraine has this duty to exercise its criminal jurisdiction, but it's also duty of Poland, Lithuania, Latvia, also to exercise its jurisdiction over those responsible for international crimes. The second provision, which is fundamental in context of the preamble and this complementary character of International Criminal Court, is that this International Criminal Court is complementary to national criminal jurisdiction. It means that it actually should work as a court of last resort when the state is for some reasons not acting, or when the state is for some reason not acting properly. And the idea standing behind all those drafters of the ICC was that they actually meant to establish the court in which the corridors of the court will be totally empty. Because the drafters of the Statute of the ICC, they thought that states will be acting so effectively and so properly that the court will have nothing to do. We, of course, note that those corridors are full with people, full with cases, full with situations, and such idea will probably never come true, that those corridors will ever be empty. However, I'm going to talk about this complementarity, which is actually the question of how to allocate cases between international and national criminal jurisdictions, how to find the balance between the global justice and national jurisdiction, how not to be a threat to national sovereignty. So admissibility will refer, admissibility in this international criminal justice context will just refer to the solution of potential conflict of different jurisdiction, of those jurisdiction jurisdictions of international and national courts. So I will try to show you how the court sees this balance between International Criminal Court and national jurisdiction. As already Professor Wilinski mentioned, we know that those issues of admissibility are put in the statute, in the Article 17. And I will not focus, I will not read aloud this Article 17. Of course, we could all see what's written here. But from this Article 17, which in first part mentions prerequisites of admissibility, and in second part, it refers to the unwillingness and defines the criteria how to assess the unwillingness of state, and defines the criteria of inability of state in third part. So from this Article 17, we could actually mention 5 prerequisites of this admissibility. The first one is the prerequisite of inaction and inactivity. Later, inaction or inactivity, you know, it's a synonym. You will find it in the literature. It's called by inaction or inactivity, and I will briefly refer to them in a moment. Secondly, we have unwillingness, which was already mentioned, and inability of state. Later, we have ne bis in idem, and finally, the gravity of the case. And now I will try to briefly refer to those prerequisites of admissibility. So, firstly, inaction. For many years, it was a prerequisite which was actually not seen by all the authors of textbooks on international criminal law. They could not, or they were not trying to read the provisions of the Article 17 a contrario, just to see that there is, beside the prerequisite of unwillingness and inability, there is also the prerequisite or the condition of inaction of state. What it means that that state is not acting. It actually means that the state should remain inactive. And it was briefly confirmed in the case of Lubanga in 2006 and in the case of Jean-Pierre Bemba Gombo in 2008, also in the case of Abu Garda in 2010. They just wanted to say, the pretrial chamber wanted to say that the state have to remain inactive. What it means actually. Because, of course, we can imagine that the state is actually taking some action. For example, it is referring its case or its situation to the ICC. But in the eyes of ICC, the self-referral is not in action. So, actually, the state can self-refer its case to the ICC, its situation to the ICC, and still it will not be an action in the context of international criminal justice. So what is action? So what is actually action? What state has to do in context of international criminal justice? It should actually prosecute its own cases. Of course, it should prosecute criminals who committed crimes on the territory of the state. For example, it will be the action, the proper action. Its procedure, its criminal conduct should be genuine, should be concrete, should be effective. Also, the ICC formulated the test just to seek the balance between its jurisdiction and the jurisdiction of the state. So it said, if I'm not going to engage in the case, your procedure before your national court should fulfill the criteria of the same person and same conduct test. It was, for example, confirmed already in 2009 in the case of Katanga by Appeals Chamber. What it means that the state should actually prosecute the same person and the same conduct. It means it's very easy, of course, it's very simple, but it seems to be simple because the case of the state should refer to the same individual and the same series of acts, of incidents, which could be under the review of the ICC. But it was a problem, for example, in the case of Kenyatta, which was standing before the ICC. The Kenyan officials used to say that they are actually prosecuting same person from the same hierarchy of organization. So actually, they were not referring to the same person, but some other person, you know, connected with Kenyatta, who was supposed to be standing before the ICC. So it has to be the same person, I mean concrete same individual, and the same conduct, I mean the concrete crimes which were committed and which could be the subject of review before the ICC. Also, there is a problem of amnesties, for example, of those amnesties or those pardons which are applied without any prosecutions. From the Polish practice, we already know the problem of pardon without the prosecution. So in that situation, if Poland was assessed by the ICC, we probably could have a case on inaction. We as Poland would fulfill this prerequisite of inaction, and the case of the potential case of crimes could be actually prosecuted before the ICC. Also, there is a problem with ordinary crimes and international crimes, because if a state is proceeding with prosecuting the ordinary crime, for example, murder, instead of crime against humanity, will it be the case for the ICC? Will it be an action? Because probably it could not fulfill the part of the test called same conduct test. But the ICC said until the elements of the crimes are to compare, it's not a problem that the state is not using international labels of the crimes. So the fact that the state is rather prosecuting murder instead of crime against humanity is not a problem for the ICC. It's not the prerequisite of inaction. And if the ICC says that there is a problem of inaction, it will not further assess the problem of the prerequisite of unwillingness or inability. The second prerequisite is unwillingness. And this prerequisite is actually focused on the assessment of the state's good faith, because it refers to the idea of due process, including the assessment whether the state is trying to shield the person from criminal responsibility, or whether there is any unjustified delay in the actions of the state, or additionally, whether the proceedings are independent and impartial. And a lot of context could be actually analyzed and critically interpreted here, because what is assessed here is actually the good faith of the state, whether the state is acting with the view to actually properly and effectively punish a person for international crimes. So it is a problem of, for example, this unwillingness will be visible when the punishment is too low, when the court applies disproportionate punishment, or whether the amnesty is applied just after the sentence, or the pardon just after the sentence, because it could be assessed as shielding the person from criminal responsibility. And also, when we talk about independent and impartial proceedings, we also talk about the status of the judge, whether the judge is engaged in any crimes committed by the state, or whether the judge is taking a part in a political system, or in political terror, or whether he is a subject of any political manipulation. It is also a question of unwillingness of state. So, and probably the most sensitive issue is unjustified delay, and why it is a sensitive issue to assess. I want to say that almost all cases and situations which are interpreted and analyzed by the ICC, they last for years. And I'm not talking they are lasting 2 years. They mostly last decades. Jean-Pierre Gombo, who was acquitted by the ICC, was sitting in the ICC for 10 years. So actually assessment that any state is making some unjustified delays would be probably not fair. Another prerequisite is inability. And although unwillingness and inability, they are very often connected with each other. They are put together in Article 17. This inability is completely different prerequisite because it refers to the state's factual capacity to proceed with criminal procedure, to commence criminal trial, to secure evidence, and to press charges, and to punish the person. And for example, Rwanda, after the civil war in 1994, was a state which was completely unable to proceed its criminal cases and to prosecute the million of criminals who committed genocide. That is why in Rwanda, other courts were engaged to prosecute those cases. I mean, Gacaca courts replaced ordinary national courts because in Rwanda there was a lack of necessary personnel to after the war to prosecute its genocidal cases. So it is very often a problem of states after the armed conflict that they do not have necessary personnel, or they could not secure the critical infrastructure, including financing of this, or there is a lack of criminal system, or lack of access of the court, or lack of the building of the court because, for example, it was bombed or destroyed. Next prerequisite is the principle of ne bis in idem, and it is it seems not to be problematic, although because everybody has some kind of idea of this principle in the head, that you cannot, be punished twice. But of course, there is a huge problem with the element of bis and element of idem, which are defined differently even in the provisions of the ICC. And in the statute of the ICC, in the Article 20, the ne bis in idem is defined differently in relation to the national court and in the relation of the procedures before the International Criminal Court. So it could be a problem, and also it could be a problem, especially in the situation when instead of real prosecution, the state applied amnesties or pardons or some other abolition issues, or some procedure when the state started some procedures before the commission of truth or commission of dignity. And the last one prerequisite I want to quickly discuss is the gravity of the case. So because of financial reasons, the ICC is not able to proceed with every grave case. It only can only proceed with cases of sufficient gravity which justify the further action of the court. So the reason is the goal of this provision is to eliminate peripheral and marginal cases. But what it means actually that the case is marginal, and what it means that the case is peripheral. We come back to the discussion which was already which was already commenced when states were trying to define, when the states were discussing the Convention on Prevention and Punishment of Genocide, and states were actually really discussing how many people have to be killed so we could call the crime genocide. Mostly, United States was for defining the number of people who have to be killed, but which with such formulation, we of course lose out of sight small tribes which consist of 60 people, for example, because United States wanted to have in this convention at least 1,000 people killed so we could call the crime the genocide. So what it means actually, the case, coming back to this International Criminal Court, what it means, the case is sufficiently, has to be sufficiently grave to justify the further action of the court. So it is the prosecutor who actually measures the gravity of the case, taking into account the conduct of the crime, the scale of the crime, the nature of the crime, the manner of its commission. Also, it's also interpreting and analyzing some individual circumstances, as for example the intent of the accused or the motives of accused, and all those elements which are elements about the numbers but also the quality of the crime are taken into account by the prosecutor. And now I would like to briefly discuss the example of the case of Mavi Marmara vessel. In this context of this Mavi Marmara vessel, the prosecutor decided not to proceed with this case because of interests of justice. But between the lines, everybody knew that 10 people killed on one of the vessels is not enough to justify the further action by the court. So 10 people killed on this Mavi Marmara was not enough. At the same time, Office of the Prosecutor confirmed that crimes against the personnel of peace missions or humanitarian operation, those crimes are graver than those crimes against civilians. Later, for example, in Magdi case, the ICC confirmed that crimes against buildings which were put on the list of UNESCO of International Heritage List are more grave than those against civilian buildings. So we could see some differentiation concerning the subjects, the protected subjects. But after all, states were claiming about this decision not to proceed with this Mavi Marmara case. But after all, appeals chamber confirmed that this is the discretion of the prosecutor to decide whether the case is sufficiently grave to justify the further action of the court. So summing up, we have 5 of those prerequisites, differently said, 5 conditions of admissibility of the case. In context of Ukraine, let's say, when Ukraine is actually proceeding with its own cases, the question will be whether there are any crimes left behind, Ukrainian courts. And now we know that Ukraine is not having, for example, crimes against humanity in the Ukrainian codex. So maybe it will be the case for the international court to proceed with with crimes against humanity committed in Ukraine. With this, I'm thanking you for listening to me, and of course, I'm ready to answer your questions. Thank you very much.
Thank you very much, Professor Wierczyńska, for this very interesting and very complex analysis of the conditions. we can obviously observe that countries have different problems in relation. We have different problems with the jurisdiction in relation to countries that want to execute jurisdiction but are not able, so they cannot that, or they should not. The question about the revenge and justice that we know from the military tribunal. And different problems arise when we have countries that are unwilling to use the jurisdiction over the cases that should cover. The other interesting topic mentioned about many others is also the element called interest of justice as one of the assets that have to be taken into consideration whether, while the ICC is answering the question of opening a case in the relation of its jurisdiction. This was also the issue of the Afghanistan case, and that learned us a lot. Maybe we'll get back to this later on. But this was also an interesting perspective from the presentation of Professor. And now I'm honored to invite Professor Hanna Kuczyńska, the next speaker. She will discuss the complementarity of jurisdiction from procedural perspective, taking our attention to the decisions of the complementarity given by the prosecutor of the ICC and the situations when and why the prosecutor should ban prosecution before the ICC, and also noticing those most important stages and the pretrial stage. So the stage of initiation of investigation and the issuing of arrest warrant. Hopefully, we will also have some comments about challenges against admissibility that can be, and we know that they often are, brought during the proceedings by states and by accused persons. Professor Kuczyńska, please, the floor is yours.
My presentation will be from a practical perspective. And I also would like to switch on the PowerPoint presentation. Maybe it will be easier to follow the topics, because the main topic of today's webinar is when a person faces the responsibility before the ICC. So when actually an accused person stands before the ICC in The Hague. And my friend, Professor Wierczyńska, discussed the admissibility of a case. And we have to remember that there is a difference between jurisdiction of the ICC and admissibility of a case. And in both admissibility and jurisdiction must be present in order for the accused to stand in The Hague before the ICC. And because this is the first webinar in this with such audience, I would like to start by reminding what is the difference between jurisdiction and admissibility of a case. Because in every case, when we want a person to be accused before the ICC, in every case, the ICC prosecutor wants to accuse somebody of a crime, of a core crime, a crime of international law, these three prerequisites must be fulfilled. So the ICC must have jurisdiction, the case must be admissible, and this person must fulfill all the elements of criminal responsibility. So this person must be individually criminally responsible, or in the model adopted by the statute, so also command responsibility counts. The person must have criminal intent, so mens rea. There must be no exclusions of criminal responsibility. And also there is another issue of immunities that as a rule, don't apply before the ICC in the vertical relation. So you see that today's topic is admissibility of a case, not jurisdiction, because just to remind you, jurisdiction of a case before the ICC is regarded in 4 areas. So the subject matter, the crimes that are in the jurisdiction of the ICC, the time when the ICC has jurisdiction, the space, so their territory, which is under jurisdiction, and the persons that are under jurisdiction. You also, of course, remember that jurisdiction of the ICC over the conflict in Ukraine is founded on Article 12, paragraph 3 of the statute. So on a declaration under Article 12. So Ukraine accepted the jurisdiction of the ICC by a declaration, not by ratification of the statute, of the ICC statute. And the declaration is very general. So it doesn't mention specific crimes, doesn't mention the end period, the end date. It's for the future, beginning in September 2015. And it gives the ICC the jurisdiction over identification, prosecution, and trying of crimes committed on the territory of Ukraine. So this is quite clear that the jurisdiction of the ICC stretches over the whole legal territory of Ukraine, also the parts under occupation since 2014. So it's not limited to the territory of the conflict or to the territory not under occupation, it's the whole territory. And now today's topic is the admissibility of a case. So we have established that there is the jurisdiction of the ICC in 4 areas mentioned before. And we are at the stage when the prosecutor has initiated an investigation. By taking a decision to initiate an investigation, the prosecutor must evaluate whether the ICC has jurisdiction and whether the case is admissible. In particular, the prosecutor must analyze whether the case is or would be admissible under Article 17, so under the prerequisites of complementarity. So the prosecutor, before he, and I will address the prosecutor as he, because now it's a he. The statute, as you see, refers to the prosecutor as to him or her. But right now the prosecutor is Karin Khan, so I will stick with he and him. So the prosecutor, before he initiates the investigation, must check whether there are any ongoing investigations in the state on the territory of which the crimes are committed or have been committed. In this case, the prosecutor initiated the investigation only 2 days after referral by state parties. So basically he assumed that there are no investigations going on that would make it impossible, that would make the case inadmissible. So we have now the state of ongoing investigation where the prosecutor concluded that all the prerequisites of investigation have been fulfilled. So there was enough evidence. The first letter is the factual prerequisite. So there is enough evidence to show that crimes in the jurisdiction of the ICC have been committed or are being committed because the jurisdiction stretches forward. So also the crimes that are being committed when the investigation is conducted are admissible, are under the jurisdiction of the ICC. The prosecutor also concluded that there are no investigations in Russia or Ukraine or Poland or Germany that would make the case inadmissible. He also concluded that the case is of such gravity that the ICC should conduct an investigation. So he conducted the examination of Article 17 at the stage of initiation of investigation, when he already knew that there is enough evidence on the crimes, and when he was sure that he was going to be able to prove that the alleged crimes have been committed and all the elements of crimes under the jurisdiction of the ICC have been fulfilled. And now, an interesting part of the complementarity problem is the problem of immunity. Because as Director Shuklina said before, the jurisdiction of the ICC and the gravity of the case lead us to a conclusion that only the highest officials should be responsible before the ICC. So the ICC is not interested in common soldiers committing war crimes, or even middle-class soldiers ordering the commission of such crimes. The ICC aims at the highest leaders, at the presidents, ministers, the highest generals. And in this case, the ICC has jurisdiction over such persons, even if they enjoy immunities in accordance with national law. In such a case, there is this horizontal immunity. So another state cannot prosecute persons who have immunity in another state. At the same time, the ICC can. So the state cannot say that our president has immunity and he cannot be extradited and accused before the ICC, because in accordance with the international treaty, so this Rome Statute, the immunities, national immunities, are irrelevant for the prosecution. So we were wondering with Professor Wierczyńska if this could be the prerequisite mentioned in Article 17. So a state is unable genuinely to carry out the investigation or prosecution. And right now, Ukraine cannot prosecute the highest officials of Russia because they have immunity in Russia, and the immunity works also in all the other states, but doesn't work before the ICC. So it seems reasonable to claim that the prosecutor may consider that the complementarity doesn't make the case inadmissible. So the Ukraine cannot prosecute highest officials, but the ICC can. So the case would be admissible. And we have to remember that the ICC interprets immunities, the irrelevance of immunities, in a very wide manner. So basically, every state that is a party to the Rome Statute is obliged to arrest and surrender heads of state that are not parties to the Rome Statute. That was the case of the president of Sudan, who is not yet extradited surrendered to the ICC, but Sudan promised to do it. Because when al-Bashir was the president of Sudan, he enjoyed immunity in his state and in another states. So the states refused to surrender him when he traveled around Africa. They refused to surrender him to the ICC. But the ICC decided that it doesn't matter if the president have immunity on the territory of other states, because the states are bound by the treaty, by the Rome Statute, and they are obliged to surrender the president of Sudan to the ICC, which never happened. But another thing happened. So the change of power in Sudan, when President al-Bashir was arrested and sentenced right now for corruption, but he's facing a death penalty for his political crimes. and Sudan promised to surrender him to the ICC last year, or actually a year and a half. And well, nothing happened since then, but we see that being a president doesn't necessarily mean that this person will never be facing jurisdiction of the ICC. So we can say that not only as Professor Wierczyńska said, in cases of crimes against humanity, the case will be prosecuted by the ICC prosecutor, but also the cases of persons having enjoined immunities in Russia will be possibly conducted by the ICC. And every state has a possibility to challenge both jurisdiction and admissibility of a case. So when prosecutor starts an investigation, he is obliged to inform the state. So the prosecutor informs the states that could have jurisdiction, you see, would normally exercise jurisdiction over the crimes concerned, and the states may inform the prosecutor that they are going to prosecute exactly these persons, both nationals and others, that they have jurisdiction over. And then the state may request the prosecutor to proceed with the case. So the state may say, wait, we have to prosecute this person on our own before our national courts. And in Article 18 of the statute, there is a procedure which allows the prosecutor to defer to the state investigation of the persons that are accused of the crimes under jurisdiction of the ICC, in the jurisdiction of the ICC. It's not an eternal deferral. The prosecutor can review the stage of investigation every 6 months. And so the prosecutor reviews if the state is willing and able to carry the investigation. If the prosecutor decides that the state is unwilling or unable to genuinely carry out the investigation, he may request the pre-trial chamber to give the decision on admissibility of the case. So if there is some investigation, as Professor Wierczyńska said, but the investigation does not fulfill the factors, the prerequisites of Article 17, still the prosecutor can proceed with the investigation. So this is the preliminary ruling where the prosecutor and the state may actually negotiate where the investigation will take place. Another possibility for the state, and not only the state, is to challenge the jurisdiction and or the admissibility of a case. The admissibility of the case is underlined because that's the main topic of our today's webinar. And the main rule of all the courts applies also to the ICC. So the ICC should check at every stage of the proceedings whether it has jurisdiction and whether the case is admissible. So the admissibility of a case should be and can be established also ex officio by all the chambers, by all the chambers of the ICC and by the prosecutor. So every chamber must be sure that it has jurisdiction over the case and the case is admissible. Also, the state may challenge the admissibility, the accused and the prosecutor. And Article 19 explains and defines precisely what state and what person can challenge the admissibility of the case. So any accused or a person for whom a warrant of arrest or summons to appear has been issued. So when the person, we will get to that in a moment, when the person was indicated as the perpetrator, he may say or she may say, but come on, I'm being investigated in Russia or in Ukraine. So the complementarity of jurisdiction is not there. It's because because national courts have priority. Also, a state may oppose the admissibility of the case on the ground that it is investigating or prosecuting the case, or the case has already been investigated or prosecuted. Also, a state which accepted the jurisdiction of the ICC under Article 12. And in such a case, there are several rules that need to be followed. So the admissibility of a case may be challenged only once. As a general rule, the challenge should be directed to the ICC before the trial begins, or when the trial begins, exactly, not later, and not more times. But in exceptional circumstances, the court may grant leave for more challenges or for a later time of the challenge. And what are the exceptional circumstances? There is no such a list. The court decides taking into consideration the state of investigation. Because, for instance, even if the first challenge of admissibility was unsuccessful, the circumstances of the case might change. So, for instance, new evidence might appear and the investigation suddenly becomes genuine and real and fair. So, for instance, there might be a change of government and the new government would support the genuine investigation. And then the next challenge to admissibility may be directed to the ICC. So you see that the challenges may happen both prior to the confirmation of charges and after confirmation of charges. And when such a challenge is made, that's the last point, the prosecutor shall suspend the investigation until the court makes a determination, but the court may allow the prosecutor to take necessary steps when evidence should be secured. So the evidence should not be lost because of such suspension of investigation. When it comes to the timing, and I changed the slide, the challenge should be made at the earliest opportunity, as the Rome Statute said. So the state must be sure that it has enough evidence to show that the investigation is genuine and adequate and fair, and in accordance with Article 17, because it is the state that needs to prove that the case is inadmissible. So the state needs to prove that it is conducting a genuine investigation or prosecution. And once the challenge is made, no new facts can be added. So this is the state of affairs that is showed to the ICC, and new facts cannot be added later. So it is very important to feel and to analyze what is the exact moment, the best possible moment to make the challenge, because on the one hand, it has to be made at the earliest opportunity, but on the other hand, the state must be able to prove that it is conducting a genuine investigation or prosecution. And now we are coming to the second problem, related to the admissibility of the case, because there is a difference between a situation and a case. And I would like to skip to this slide. Did I skip to the next slide? Thank you. Because when we are dealing with the topic of admissibility of a case before the ICC, we should remember what are the consecutive stages of procedure before the ICC. In the case of Ukraine, we are at Article 53. So initiation of an investigation by the ICC prosecutor, where the prosecutor concluded the case is admissible. Another stage that will come soon is Article 58, issuance of a warrant. So the prosecutor must be certain that there is a suspect, a perpetrator who committed concrete crimes. And then if this person seems to be the perpetrator and the prosecutor has enough evidence, he asks the pretrial chamber to issue a warrant of arrest, or if the person is willing to cooperate, a summons to appear. So the person who doesn't want to come to The Hague is arrested. The person who wants to come to The Hague and cooperate with the ICC can come freely without the need to be arrested. When the person is secured in The Hague, when the person is in The Hague, there is the third stage, confirmation of charges by the pretrial chamber. Confirmation of charges is a sui generis accusation. So a specific procedural type of accusation when the case from the investigation stage is brought to the trial stage. And only when the charges are confirmed in accordance with the specific procedure, a trial chamber is constituted, and the trial chamber, before the trial chamber, the trial takes place. So there are 4 stages. We are at stage 1. And why is it important? Let me go to this slide, because in the case of Ukraine, as with other cases, a referral was made by state parties of a situation. So the whole conflict in Ukraine is being investigated. There are no perpetrators yet, no specific crimes yet. The whole conflict is being investigated. There is even a question whether the prosecutor of the ICC is obliged to investigate a situation when a state referral is made. The prosecutor claims that he has no such obligation, but so far in all the cases of referral, he conducted an investigation. And now, on the basis of the referral of the situation, the prosecutor must define specific cases. So the situation justifies the initiation of the proceedings before the court, and the situation includes a whole range of behaviors restricted to time, territory, and potential perpetrators, and the case refers to specific events, which is 1 or more crimes under jurisdiction of the ICC. So in the limits of a single situation, the conflict in Ukraine, the prosecutor can now initiate a number of proceedings, a number of cases against, as we assume, the highest Russian officials responsible for the most grave crimes. So decision to prosecute a case consists of 2 decisions. First, the prosecutor issues a decision to investigate a situation, and then he takes a decision to prosecute a particular case and a particular perpetrator. You can see on the web pages of the ICC that there is a separate record for situations and cases, and the documentation of a situation is then repeated in the situation, in the record of the case when a case is commenced. Okay, 5 minutes. So I will be going to the end. So when the prosecutor asks the pretrial chamber to issue a warrant of arrest or a summons of appeal, again, there might be a problem with complementarity, because now we have the perpetrator and criminal acts, and this is the proper time when we can conduct this test, same person, same behavior test. Because now it is only now that the perpetrator is indicated. So we say this is the person responsible for crimes in the jurisdiction of the ICC. And Article 58 defines the factors that need to be the conditions that need to be fulfilled so that the arrest warrant could be issued. So first of all, the factual prerequisite. So reasonable grounds, that is evidence. The arrest of the person must be necessary to ensure the person's appearance at trial. And we have to remember the accused must be present during the trial. The ICC recognizes no in absentia trials. So we need the person to be physically present at the Hague. And therefore, al-Bashir is being chased by the arrest warrant for more than 10 years right now. The arrest warrant was issued in 2012. Okay, and I talked about the confirmation of charges that may happen later, which is a contradictory hearing where the accused may present evidence of his innocence. Maybe he is not forced to, but may, and the prosecutor must convince the court that there is enough evidence to prove the person's guilt. There must be reasonable basis to believe that this person committed certain crimes. And to conclude, the procedure I just described seems to be designed for states that don't wish the ICC to prosecute crimes under international law. At the time being, we have, I think for the first time, a very peculiar situation in Ukraine, because the ICC is supporting the national prosecution of crimes in Ukraine. There is a common gathering of evidence taking place on an unprecedented scale. So the ICC, together with the Ukrainian prosecutors, are gathering evidence, ensuring that the evidence is secured in a proper way, that it will be admissible both in national courts and before the ICC. So I think we are experiencing the new role of the ICC. So it is not only the prosecution itself that it is most important right now, but it is the documentation of the conflict that is at the focus of the ICC prosecutor. Because the point is, the guilty persons must be held responsible, whether before national courts or the ICC, or even Polish or German courts. And last week, the ICC prosecutor gave a speech, 1 year after speech, where he maybe indicated the cases that he was going to prosecute, that he was looking into deeper, and he was certainly only dealing with Russian crimes. There is no doubt about it. He was speaking about terrible suffering of Ukraine and Ukrainian people, dark hour, battle for humanity. And he was mentioning investigations that were conducted and deepened in Borodienka, Bucha, Kharkiv, and especially maternity hospital in Mariupol. And what we should also remember, that also although the conflict is still ongoing, the law should be on the front lines, and the law must be seen to be potent, either before national courts or the ICC. Thank you for your attention, and I'm waiting for your questions.
Thank you, Professor Kuczynska. So as we see, we just had a second very interesting intervention. We could say that this one was more about acting ICC, so admissibility and complementarity in action. What problems would face the ICC once it will open not only investigation of the situation, but once it will open a case before the court. we can also have a comment about the last element of the presentation, mentioning cases by the ICC that they are interested in. We can observe that the more there is a discussion about the ad hoc tribunal for Ukraine, the more ICC is trying to be active and showing its interest in speedy proceedings. We already know that the speedy is not the most important for the ICC, and we saw that in different cases opened years ago before the ICC and still being at the pre-trial stage, or even before opening a case, before presenting charges. We have this excellent perspective from presentation of Professor Kuczynska, acting ICC and the issues